Welcome to the special Short Circuit live recording at the University of Virginia. Thank you to the Federalist Society and to the Virginia Law Review for hosting us. Today we will be discussing 3 Fourth Circuit cases on retaliation in prison, judicial immunity, and zoning with 3 amazing panelists: Gregory Tsui, Rachel Bayefsky, and Lawrence Solum. Gregory is an attorney with the Roderick and Solange MacArthur Justice Center's Supreme Court and Appellate Program. He is also a lecturer here at UVA. He currently teaches a class on lawyers, clerks, and judicial decision-making. Gregory's MacArthur practice deals with issues like qualified immunity, federal habeas corpus, the Fourth Amendment, the First Amendment, and Section 1983. Greg, I'll call you Greg, if that works.
That would be great.
Got his JD from Yale, clerked for Justice Sonia Sotomayor on the United States Supreme Court, and litigated at Sidley Austin. Greg, thank you for being here.
Oh, thank you, Anya. So nice to be here.
Rachel Bayefsky is an associate professor of law here at the University of Virginia. She's an expert on constitutional law, federal courts, civil procedure, and legal theory. We will post 2 of Rachel's latest articles in our show notes. The first article is on public law and private right models of litigation, and the second one is on judicial institutionalism. I highly recommend you read them both. Rachel got her JD from Yale and her Doctor of Philosophy in Philosophy from Oxford. She taught at Harvard as a Klimenko Fellow, clerked for Justice Ginsburg on the United States Supreme Court, and litigated at Akin Gump before joining the faculty here at UVA. Rachel, thank you for being here.
Thank you for having me.
Lawrence Solum needs no introduction. He is an internationally recognized legal theorist who works in constitutional theory, procedure, and the philosophy of law. His series of articles on constitutional originalism have shaped contemporary thinking about the debate between originalism and constitutional theory. Here at UVA, he teaches constitutional law, civil procedure, and other fascinating classes like law of artificial intelligence. In 1992, he published an article titled Legal Personhood for Artificial Intelligences, 22 years ahead of its time. We will post this article as well as a link to Lawrence's influential legal theory blog in the show notes. Lawrence got his JD from Harvard. He clerked on the Ninth Circuit for Judge William Norris. Welcome, Lawrence.
Thanks so much. I'm very excited.
Before we begin talking about the cases, let me briefly mention several things about the Fourth Circuit. The Fourth Circuit assumed its present 5-state composition in 1866, even before the creation of modern appellate courts through the Evarts Act of 1891. These states are Virginia, West Virginia, Maryland, North Carolina, and South Carolina. From day one, the court's seat has been in Richmond, Virginia, in the building that was built in 1858 and that originally housed the post office and the customs office. The building is now known as the Lewis Powell United States Courthouse, after a United States Supreme Court justice who loved his life in Richmond so much that he originally asked President Nixon to not nominate him to the highest court in the land. The Fourth Circuit currently has 19 judges, 4 of whom are senior. Out of the 15 active judges, 8 were appointed by Democrats and 7 by Republicans. Most recently, Trump and Biden got to appoint 3 each. The court is known for its collegiality. Before COVID, at the end of each oral argument, the judges used to come down from the bench and shake each advocate's hand. The practice has been resumed after the pandemic, though on a more ad hoc basis. The court is also known for issuing decisions on this century's most hot-button issues, such as indefinite detention of American citizens in Hamdi versus Rumsfeld, a state ban on same-sex marriage in Bostic versus Schaefer, and whether Obamacare tax credits can be used on federal exchanges or only on state-operated exchanges in King versus Burwell. This term, the docket is somewhat less controversial, especially relative to the Fifth Circuit and the D.C. Circuit and, oh yes, the Colorado Supreme Court. But there are plenty of interesting opinions to discuss. I am going to use my prerogative as a moderator and begin with the First Amendment retaliation case, since I'm still recovering from my oral argument in Gonzales versus Trevino. Gregory, get us started with Jones.
Sure, Anya. So this is an important case that was decided this year, came out in January, and as you said, it's a case about First of all, a dangerous and degrading experience that the plaintiff suffered in prison that was made even worse by the retaliation he then suffered when he tried to seek redress for that violation. So that's the first thing I would say it's about. The second thing I would say it's about is qualified immunity and what that doctrine, which needs no introduction, does to the law and the decency of the law in particular. So this case was decided by a panel of judges. The chief judge, Judge Diaz, Judge King, and Judge Wynn all agreed to the majority opinion, and Judge King concurred separately.
And Judge Wynn is retiring, right? And the opening up an opportunity for another Biden nominee.
I'm sure you're right. I didn't know that, actually.
Google this, but yes.
I do know Judge Wynn went to this law school, got a master's of law here, so shout out to the Who's. Judge Wynn wrote the majority. So this is a case about Jordan Andrew Jones and the experience he had in 2015. At that time, he was a prisoner in a North Carolina facility called Avery Mitchell. And in April of that year, prison officials saw him swallow something. The officials claim that they thought it was contraband. Mr. Jones claimed that it was candy. Regardless, this prompted the officials to put him in what was known as a dry cell, a cell where the water is shut off to both the toilet and the sink, and instruct him that he would not be released from the dry cell until he produced 3 bowel movements to try to extract whatever it is he had swallowed. And it's those bowel movements that are the subject of this degrading experience that I was talking about. So he complied. He produced 3 bowel movements over the course of that day at 2 o'clock, at 4:30, about 4:30, 5:30, and at 9. In the first 2 bowel movements, the officials followed basically the same procedure. So they handcuffed him and then brought him a portable toilet that had a red biohazard bag. And let me apologize for going into the particulars of this, but it's important because these details are what made this experience so degrading. So, he's brought a toilet. They then unhandcuff him so that he can go to the bathroom. They provide him with toilet paper, and they close the door. He produces the bowel movement, and then they re-handcuff him, remove the toilet, and the officials inspect the stool, and they don't find anything. So that's the first 2 bowel movements. After that, he is provided a meal. But the problem is, after neither of these experiences is he provided with supplies to wash his hands, to sanitize himself. And he is also not given utensils to eat the meal. And so he's thus forced to eat the meal with his soiled hands, which he does. Then we get to the 3rd bowel movement, and it gets worse. Because for the 3rd bowel movement, 2 other officials supervise this one, and they follow a different procedure. They bring the toilet again, but it doesn't have a bag. They don't close the door when he's using the restroom. They leave him handcuffed while he's using the restroom, and they don't give him toilet paper until after the stool is inspected. And I use the passive voice there because this time they have him inspect his own stool using tongue depressors. And they make him do that first before they give him toilet paper, which is to say that he's forced to pull up his boxers because he's been forced to strip down to just his boxers and his T-shirt. He pulls them up after using the bathroom, but before being able to clean himself so that he can inspect the stool, and only then is he allowed to clean himself. And he's still not provided with supplies to wash his hands or sanitize. After all of this, no contraband is found. Nevertheless, he remains in the dry cell, and it's not until the next day, until about 5:30 in the morning the next day, that the water is turned back on to this toilet and the sink. And it's not until 8 p.m. the next day that he's actually provided with supplies and the ability to shower, to clean himself, and to get dressed. And so in total, as the Fourth Circuit noted, he spends 23 hours in his soiled clothing. He spends 30 hours without the ability to shower, access to soap, or being able to clean himself. And he spends 15 and a half hours in a cell with no running water after the first bowel movement. As everyone agrees, and by everyone, I mean even the defendants in this case, because they conceded this at oral argument, this was unsanitary, disgusting, and a violation of the prison's policies, which forbid inmates from being forced to inspect their own stool for sanitary and health reasons. So that's phase one of this case, because as I said, it starts with a degrading violation, and now it's about to go into phase two, because in phase two, he tries to seek redress for what's happened to him, and he files a grievance. Prisons normally have a procedure whereby you can raise complaints internally in an administrative process, and he does that. He does that 3 days after he's finally released from the dry cell. That grievance is found meritorious. It's reviewed by prison staff. They find it has merit. They recommend officials at the prison for discipline. So as I've described, it has merit. But shortly after that, he starts hearing comments from prison officials that he's probably going to be transferred because of his grievance. One official says that on May 26th. Another official says that on June 22nd. On August 6th, the unit manager of the prison calls him into the office and asks if he's trying to get transferred by filing these grievances. And when he says no, the unit manager says, "I can't tell." And then finally, on October 13th, the assistant superintendent at the prison calls him into his office, tells him he needs to ease up, quote unquote, on the grievances because they are, quote, not helping him stay at the prison. And the next day, either the next day or the day after, he's transferred to a different prison. And in particular, he's transferred to Lanesboro Correctional Institution, which the evidence in this case shows is widely known to be a more dangerous facility. It's a facility where someone who actually assaulted Mr. Jones was then residing. And it's a facility that didn't have access to a kind of vocational program that Mr. Jones was taking advantage of at Avery Mitchell. That kind of sets the stage for the facts of this case.
Yes, and then we have a fascinating legal opinion on two issues. So the first one is, both of them are in the qualified immunity posture. And what's really interesting is that the Fourth Circuit has this unusual burden sharing framework, right, where the plaintiff has to first show that there was a constitutional violation, but the burden is on the defendant to show that the constitutional violation was clearly established. That is not how the majority of circuits are doing it.
That's exactly right. It's so interesting you noted that. I took note of that too. The Fourth Circuit specifically drops a footnote to kind of comment on this, and they note that so there are two prongs of qualified immunity, and so there are kind of four permutations of where you could put the burden of proof for those prongs on, and they note that each one of those permutations has been adopted somewhere. But as you say, the Fourth Circuit is unusual in that they put the burden of proof, and I'm making scare quotes now for our listeners, right, on the government at the second stage, which is really kind of a question of law, a question about clearly established law, taking the facts as they need to be construed here at summary judgment, but also at a motion to dismiss. So that was an interesting feature of the case.
Yes, and so what do they do with the with this clearly established prong on the Eighth Amendment claim?
Yeah, so on the Eighth Amendment, they apply qualified immunity. They say they go out of their way. The court goes out of its way to acknowledge that this was degrading, that this was unsanitary. They express, quote, serious doubts about the constitutionality of the official's actions with respect to the conditions of confinement, because this is an Eighth Amendment claim alleging that this experience that he was put through created unconstitutional conditions of confinement, that they rose to cruel and unusual punishment. They expressed doubts about it, but they didn't go so far as to say that it did violate the Eighth Amendment, and instead they said, whatever the truth of whether there was a violation or not, it wasn't clear to every reasonable official in 2015 that was true, and therefore they're immune.
Why go through all this trouble and provide this analysis on how it kind of looks like a constitutional violation, but then kind of pull away from actually at least saying, yes, it is a constitutional violation, and going forward, it will be clearly established, even if it's not in this case? Yeah,
I mean, I think it's exactly kind of what you were alluding to. So, this is a classic Pearson versus Callahan decision. It's a decision that doesn't tell us what whether there was a violation at prong 1. It just talks about whether it was clearly established at prong 2. And a reason you would want to have a decision on prong 1, as you said, Anya, was to at least set the table going forward, at least put officials on notice going forward so that hopefully we won't be back in the same position a year from now. And gesturing at constitutional concerns, acknowledging factually the degrading and gross nature of this, I think was an effort to sort of provide that notice, but to be clear, it didn't. This is not a decision that people can point to later and say, aha, at least after April 2015, we know it is unconstitutional to do this. So it's kind of a half-baked prong 1
And it's strange,
decision.
right? Because one of the reasons you have this Pearson framework is so courts don't have to spend their judicial muscle on thinking about whether there is a constitutional violation. But here, the court is clearly spending its judicial muscle thinking about this, but it doesn't go all the way. And a dissent calls them out on that, doesn't it?
That's right, yeah. So Judge King concurs separately, and he says, I agree with what my colleagues have written, but they didn't answer this prong 1 question, and I would do so.
And what about the First Amendment retaliation claim?
So that claim, again, they go through the qualified immunity analysis, but they deny qualified immunity here. They say that at least on the facts as taken at summary judgment, which is to say construed most favorably as reasonably possible in favor of the non-movement, so here Mr. Jones, at least on those facts, at least if the story is what he says it is and the evidence shows it is, every reasonable official would have known that you cannot transfer someone and repeatedly threaten them with transfer in the lead up to it in retaliation for raising a prison grievance, which is a classic protected activity under the First Amendment.
So he gets to go forward, at least on his First Amendment retaliation claim, but the Eighth Amendment, all these indecencies that we heard about, that you discussed, those claims die.
They do, it's kind of an odd result that the claim that moves forward, isn't what set all of this in motion. It's kind of that it's not icing on the cake, but it's the kind of additional harm that bore out of the original violation. So it is a strange result, but it does at least let him go forward on the First Amendment claim.
Our listeners would know about Taylor versus Riojas. We spent quite a bit of time discussing that decision because it's kind of probably the latest, most significant victory for qualified immunity opponents at the Supreme Court, where the court seemed to signal that at least when it comes to prison conditions, they're not going to be looking at the clearly established prong with that level of exactness as in Fourth Amendment cases, for example. But the court doesn't really seem to give much credence to that in this opinion.
Yeah, that's how I read it. I mean, to their credit, they do explicitly acknowledge that in the Eighth Amendment context, the law doesn't require close specificity as it does in the Fourth Amendment context. So that's certainly a correct statement, but then in the manner they applied the analysis, I'm not sure it was totally consistent. As you say, they specifically reject Taylor as part of the body of law that could provide kind of a robust consensus of other authority, although Taylor would have been binding on this court, so could have been slotted either in the on-point precedent or in the robust consensus of persuasive authority. But regardless, they distinguish it and they say, basically, that was way worse. And they do that for every case that's thrown out, by Mr. Jones's counsel. And by way worse, they kind of pick apart these factual differences and say, therefore, well, in this scenario, reasonable officials might have been confused.
Lawrence, did you have anything to add?
Just that this case, like many others, raises, fundamental questions about qualified immunity. And qualified immunity doctrine is under a lot of pressure now. And notably, it's under a lot of pressure from scholars who argue that it was just made up by the Supreme Court and that it has no sound basis in the original meaning of the statutes that are triggering liability. Now, there's some scholarly dispute about that, but that would be the kind of argument that might induce the current Supreme Court to reconsider qualified immunity, which I think is obviously one of the most controversial doctrines of its kind. Certainly in the academy.
Especially when we are talking about a constitutional violation like this one, requiring a case that is very similar to something that happens here, doesn't seem like it's something that the only thing that could put a reasonable official on notice. It seems like there are other things that would have warned a reasonable official that they shouldn't be doing this.
No, I think that's exactly right. And one of those things which the court does acknowledge is that they were clearly in violation of the prison's own policies. And this is something that the Supreme Court has used in cases like Hope as
Hope
an
versus Pelter,
alternative.
that's right.
Exactly, an alternative form of notice. Because if qualified immunity is just about making sure officials know in advance that what they're doing violates the law, then as you say, there could be other ways to do that.
All right, I think we about covered it. Let's do the transition from qualified immunity to judicial immunity and talk about Gibson versus Goldston.
Thank you. So Gibson is a Fourth Circuit case that was decided in October of 2023. It was written by Judge Wilkinson, and then Judges Gregory and Senior Judge Motz joined. It's an appeal from the U.S. District Court for the Southern District of West Virginia from Judge Volk's case, and it's an Institute for Justice case. So the Fourth Circuit in this case affirmed the decision of the District Court. So that's the basic procedural posture. Gibson is a case about the doctrine of judicial immunity. And judicial immunity is one of a family of doctrines that immunizes various entities and officials from suit. Qualified immunity, which we were just discussing, is another such doctrine. But judicial immunity is a distinct doctrine. And what it means is that you cannot sue judges for their judicial acts. So why do we have judicial immunity? Well, the U.S. Supreme Court has offered various justifications. They say that judges should be free to decide cases according to their own convictions. They should not live in fear of personal repercussions if they rule against a party and then that party brings a lawsuit. The Supreme Court has also suggested that, if judges were worried about protecting themselves, they would feel the need to make a record very carefully about how they were deciding a case, and that would be distracting and would potentially distort the decision-making process. And then the Supreme Court has said that there are other remedies for judicial misbehavior, notably appeal of the judge's decision and impeaching the judge. So judicial immunity, those are some rationales for it, and it's a form of absolute immunity. So that means that judges who are acting in a judicial capacity cannot be held liable for damages no matter what, even if they intentionally or maliciously violate clearly established rights. And so that's a difference between judicial immunity and qualified immunity, which we were just discussing, that an officer who's protected by qualified immunity may not be protected if they intentionally violate clearly established federal rights. So a stark example of the strong effects of judicial immunity comes from a U.S. Supreme Court case from 1978 called Stump versus Starkman. It's a very tragic case, I think. And there, an Indiana judge had approved a petition that was filed by parents of a 15-year-old girl to have her sterilized without her knowledge. Her parents appeared to have believed that she was mentally ill and that she should therefore be sterilized. So many years, she didn't know at the time, and many years later she wanted to have children, and she found out that she was sterile. And so she sued this judge for damages under the Civil Rights Statute 42 U.S.C. 1983. And the Supreme Court held in that case that the judge's approval of the sterilization petition was a judicial act, and so he was protected by absolute immunity. So it's very, strong medicine. I don't know whether it's medicine, but it's very strong. So judicial immunity is absolute, but it's absolute provided that judges are engaged in judicial acts. Judicial immunity is not available if the litigant who's suing the judge can show that the judge was not performing a judicial act. So this is the question at issue in Gibson. Was this West Virginia judge performing a judicial act such that judicial immunity would apply? Or was this judge engaged in a non-judicial act, in which case she could be sued? So the facts of this case are quite dramatic. Basically, you have this West Virginia family court judge, Louise Goldston. She issues a divorce decree to Gibson and his ex-wife. Later on, the ex-wife returns to Judge Goldston's chambers with a petition for contempt. And she alleges that Gibson failed to turn over some items that were included in a property distribution settlement. So Judge Goldston, in the middle of this hearing, drives over to Gibson's residence with a bailiff, with Gibson, with his ex-wife's attorney. And the purpose of going to Gibson's residence is to look for the contested items. So Judge Goldston really plays a hands-on role in directing this search. So the Fourth Circuit opinion includes some quite colorful details. So according to the opinion, when the ex-wife identified some photographs that were hanging on the wall as being hers, Judge Goldston said, "Take them." And when the ex-wife said that their old DVD collection was downstairs, Judge Goldston accompanied her down and told her to go in there and pick the ones you want. And Gibson, through part of these proceedings, was taking a video recording. So later, disciplinary proceedings were lodged against Judge Goldston, and the West Virginia Supreme Court of Appeals censures her for serious misconduct, orders her to pay a $1,000 fine. And during these disciplinary proceedings, it emerges that Judge Goldston had carried out previous such home visits in the past. So that's as far as the disciplinary proceedings went. But the issue here in this particular case is about a lawsuit that Gibson filed in federal district court against Judge Goldston and others present at the search. So Gibson says that this was a warrantless search and seizure of his property and that this violated his Fourth Amendment and 14th Amendment rights. And the question then is, can Gibson sue Judge Goldston, or is she protected by judicial immunity? So the district court said no, that she is not protected by judicial immunity, and the Fourth Circuit affirms. And in this case, the Fourth Circuit reasons that Judge Goldston was engaged in a non-judicial act. According to the court, she, quote, clearly exceeded the most common understandings of the proper judicial role. Now, Judge Goldston had argued that she did act judicially because she went to Gibson's house in service of the resolution of a family court matter, that is, to ensure that parties comply with marital property distribution agreements. But according to the Fourth Circuit, the search of someone's home and the seizure of its contents are executive acts. They're not judicial acts. So Judge Goldston's activities are not eligible for the protections of judicial immunity. According to the Fourth Circuit, she might have had the authority to order a search, but the proper authority to actually conduct the operation lay with the local sheriff's department or some other law enforcement agency. So the Fourth Circuit says, judges should not be taking law enforcement into their own hands, and if they do so, they're no longer protected by judicial immunity. So the case against Judge Goldston can continue. So what are the broader kind of takeaways from this case? Reading the facts, it might seem clear that, someone who acted as the judge did in this case should not be protected by an immunity doctrine. But the nature of immunity doctrines is to protect people who are accused of violating the law, including in egregious ways. That's how immunity doctrines operate. The Fourth Circuit in this case, though, says that there are limits. Judicial immunity is absolute, but only when a judge is engaging in a judicial act. And this case demonstrates how courts courts can use judicial immunity to police the bounds of the separation of powers, to differentiate between judicial and executive acts, and to clarify that judges are protected by judicial immunity only when they're engaging in judicial acts as distinct from executive acts.
There is this dramatic episode during the standoff. And by the way, you can watch the video on YouTube. If you go Gibson versus Goldston, you can see the judge kind of sitting there with her shoes off and telling people, oh, go ahead, telling the wife, go ahead, take whatever you want. And the thing was that the judge actually told Matthew Gibson that he can't record. And you have this bailiff who essentially is there at her service, but he feels like something is going on here that's not quite right. So the bailiff, without letting the judge know, goes ahead and records at least part of that home search, and that's how we know a lot of what happened. And given the way the opinion is written, it feels like they were really impressed by that video of her kind of sitting there on that chair without her shoes and just her entire appearance.
Yes, certainly. So the video recording certainly dramatized what happened, and also, was important in making a record of what had happened, and so that does seem to have been persuasive to the courts in this case. And I think, perhaps it suggested to the courts, further reasons why what the judge was doing was outside the bounds of her judicial role. That if we think about what judges do, we think about them, sitting in courtrooms, perhaps with robes. I mean, the court says it's not necessary for a judge to wear a robe in order to carry out a judicial act. But it does seem like the way in which this search was carried out has these details that suggest that it was not, being fulfilled in the judicial capacity or as part of a judicial act.
And of course, the way that judicial immunity and qualified immunity interact is that just because you don't get a judicial immunity, and that's not the case here, but just because you don't get judicial immunity doesn't mean you don't get qualified immunity. So often in situations where a judge is not acting as a judge, but acting as an executive, they could still be protected by qualified immunity, which is something that is stark because you have several layers of protection when you happen to work for the government. Patrick, come here for a second. Patrick Giacomo is here with us too. Patrick argued the Gibson case. So I'd like you to tell our audience a little bit about how the oral argument went.
Sure, thanks. Yeah, this was a fairly lively oral argument. I think one of the things that really made this case kind of unique, and the fact that there have only been 4 or 5 such cases across the country, basically ever, that involve this type of exception to judicial immunity. What made this case unique, though, was the West Virginia Supreme Court's ruling and saying kind of very broadly in its disciplinary order that what Judge Goldston did here exceeded her authority as a judge and violated basic separation of powers concerns both under the West Virginia Constitution and under the U.S. Constitution. And so I think, without something like that to come into a case like this, it really is sort of a crapshoot as far as whether the panel will be extremely deferential to the fact that they're dealing with a judge or whether they're willing to actually call out this sort of bad behavior. And here, I think that kind of carried quite a bit of weight, as did the video, because again, you could, if you go listen to this argument, there's a lot of discussion on the other side about the argument that this wasn't actually a search. That was kind of the meat of the argument on the other side. And the panel wasn't buying that at all. But you have to wonder, without the video, that was frankly the video taken by the bailiff inside the house, whether that argument might have actually carried quite a bit more weight. And so thankfully, we didn't have to deal with that here. And this case was very well litigated by our friend John Bryan in the district court. And so once we got to the Fourth Circuit, between the video evidence and the West Virginia Supreme Court's ruling, I think we had a much easier case to say, hey, this judge acted so far out of the bounds that she was no longer acting as a judge.
Thank you, Patrick. Also, shout out to our other friends, Hugh Eastwood and Beavis Schock, they litigated a very similar case involving judicial immunity in the Eighth Circuit Rocket, and the Fourth Circuit relies on that judicial immunity case to basically bolster its own decision that the judge did not act as a judge.
I guess one thing I've also found it striking, the idea that, there's a video of the judge overseeing the search in the home. And I guess just building on that theme, curious what you both think, building on the theme of how much work that did in the case, you could imagine a judge directing the search in a way from chambers. I mean, when judges sign search warrants, for example, they often specify the items to be searched and the places to be like you could see a judge kind of overseeing, and again, I'm doing scare quotes for our listeners, overseeing the search, but in a much more judicial way. And I feel like that would have been a harder case. This case just pushed that line so far because, it just looked so executive, as you said, Professor Bayefsky.
Yes, I mean, the court drew this distinction between ordering a search on the one hand and conducting the operation on the other. And so perhaps you can imagine cases that come closer to the boundary line between the two, where the judge is ordering the search in a way that is more specific and seems more similar to conducting the search. But I think in this case, it just struck the court that this was very clearly actually engaging in the executive function of conducting the operation.
Lawrence?
Just the facts are so egregious that you understand why the court did what it did. But is it really the case that this sort of is an inherently non-judicial function? I'm not so sure, because certainly in many other legal systems that have, for instance, examining magistrates, this would have been a judicial function, right? And you could imagine that some state concerned with the difficulty of enforcing orders in cases of this like would authorize judges to go to the premises and to oversee the enforcement of the order and provide sort of on-the-spot resolution of the controversies that might arise. And if it were authorized, it would be a judicial function. So here, what may really be going on is not that we have an inherently non-judicial function, but that instead we have a judge who is acting in a way that just looks outrageous and somewhat crazy, right? And so that's not the law, but that might be what's motivating the court to deny the judge judicial immunity.
Yes, well, I don't think there's a platonic ideal of a judicial function that would apply across different legal systems. I suppose the court was just thinking about in our particular legal system, what is it that we expect judges to do? And a judge could be protected by judicial immunity, or another official by another form of immunity, even if they abuse their role or act egregiously. They could nevertheless be entitled to immunity protections. In this case, the court, at least doctrinally, suggested that the judge wasn't even acting as part of that role. But one of the motivating factors might have been the view that the abuse here was so egregious.
Yeah, it's a fascinating case. It does show that facts matter a great deal. Judges are people too. And if that bailiff is hearing us right now, I think plaintiffs owe a lot to that bailiff actually performing that recording. Now let's talk about our third case involving development, zoning, and equal protection claims. Lawrence, you want to get us going on that?
Yes, so this is SAS Associates versus City Council. So the developers have a large project. They've submitted a plan. The plan requires zoning variances. So the Planning Commission, which is the sort of expert body, approves the variances, but then it moves up to the next level, the city council, and the city council denies the request for variances. And now I'm going to simplify the facts a little bit.
Thank you.
The only real substantive reason expressed in the record has to do with the possibility that this development would cause flooding. But the flood plan administrator, the official in charge of this particular aspect of city policy, says that the development will not cause flooding if it complies with the requirements that have been imposed. So the only reason is flooding, and the only evidence in the record says that there will be no flooding problem. So the developers file suit, and they have an equal protection theory. Now, equal protection doctrine. There's no suspect or quasi-suspect class here. This is a non-suspect class, and so the appropriate level of scrutiny is rational basis scrutiny. And so at this point, there is no rational basis in the record. The city hasn't provided any reason for denying the zoning variances that's supported in the record. Now, there may very well be such a basis that would emerge later on in the litigation, but on the basis of the record, there's nothing here. Okay, so there's a 12B6 motion, right? This is a pleading motion. For failure to state a claim upon which relief can be granted. And in the background of this motion, we have two Supreme Court decisions, Twombly and Iqbal, these very strange and radical decisions that seem to bring back fact pleading. So you have to plead facts establishing each element of your claim. Okay, so there's an appeal. It goes to the Fourth Circuit. Judge Wilkinson writes the opinion which affirms the district court, says that it's proper to grant the 12B6 motion. So what Judge Wilkinson's reasoning begins with the idea that you must plead facts establishing animus in a case like this. So this is shocking, just completely shocking. The case that's being cited is turns out when you trace back the authority, these are cases that are about racial discrimination, which triggers strict scrutiny, and situations in which there is a policy that has a discriminatory effect, right? But it's not a race-based policy. So in those circumstances, you have to prove animus in order to get to racial discrimination, which gives you strict scrutiny. But those cases have no application in this situation. This situation, we're not asking for strict scrutiny, we're asking for rational basis scrutiny, and there is intentional discrimination here on a non-suspect basis, in fact, on several non-suspect bases, right? So you get rational basis scrutiny, and the idea that you have to prove animus, some kind of forbidden motive, is just ridiculous as a matter of constitutional law. But nonetheless, that's what Judge Wilkinson concludes, citing authority that does not stand for the proposition for which it was cited. It's sort of shocking. Then Judge Wilkinson says that in order to bring this kind of a claim, a non-suspect classification claim, you have to establish that all of the facts are identical. And here he points out that there were lots of things that were different between this denial of a zoning variance and other cases in which the variance was granted. For example, this claim occurred at a different time than those claims, and this claim occurred at a different place than those claims, and therefore you haven't met your burden to establish that the facts are identical. Well, again, this is an elementary mistake. The question is not, are the facts identical? The question is whether there was a rational basis. And these are obviously not sufficient. You can't just say it happened at a different time, and therefore it's rational. You can't just say, well, this is a different location, and therefore it's rational. If you could argue that those things establish a rational basis, every decision that any government ever makes would have a rational basis because the time and place are always different. So again, the legal reasoning is off. So now the court seems to recognize this because they go on to talk about what the rational basis might be. So for example, the opinion goes outside the record and says, well, outside the record, we can find that there's a lot of population growth here. And then the court suggests that that population growth might lead to differential environmental impacts. Now, there's no evidence for that, even from outside the record, and therefore there is a rational basis here. Well, you can't do that. The Court of Appeals can't develop its own factual record in this procedural posture, a 12b6 motion. It has to rely on the universe of facts in the complaint. And furthermore, they couldn't even do this if this were at the summary judgment stage, right? So again, an egregious error. What should the pleading burden have been here? What should the complaint have included? And it's pretty obvious that it can't be that what you do in your complaint is you go through every possible conceivable basis for the decision and negate that conceivable basis. That would result in complaints of tens of thousands or hundreds of thousands of pages, right? Because we can dream up all kinds of possible justifications. The pleading burden has to be to negate those bases for the decision that have some support in the record of proceedings. So here, and again, I'm simplifying a little bit, really the only basis for the decision was the threat of flooding. But on the record, the city's own expert said that there is no such risk. And therefore, bottom line, the district court should have been reversed. Now, when we get to summary judgment, I think this complaint's a loser, right? Because now the city's attorneys get to come up with the reasons for the decision. So that raises a question, why such a terrible decision? Really just an awful decision, both on constitutional law and as a matter of civil procedure, how you address a 12b6 motion on appeal. And there's a couple of possibilities here. One is sort of sloppiness that the lawyers, I don't know, I didn't read the briefs, so I don't know what the lawyering was like. I don't know what was said at oral argument, but it's possible there's bad lawyering or the clerks did a really bad job of researching the law. Those are possibilities. And there's another possibility. I think this is more likely. The law clerks involved in this case are likely to be very, very sharp. And certainly Judge Wilkinson is himself a highly respected judge who is capable of doing excellent work. So it seems to me the most likely hypothesis is that the Fourth Circuit wanted the case to come out this way. They wanted it to come out this way because they think that if they reversed and remanded, it would be fruitless, because once we get to the summary judgment stage, we're going to reach the same result. Now, I teach civil procedure, and I put great weight on the rule of law. So I think that that's still abysmal behavior by the Fourth Circuit. But it's understandable behavior, and especially understandable if you're in favor of this kind of results-oriented judging that sort of is willing to push the law aside to get to a result that you think is sensible. Certainly, Judge Richard Posner of the Seventh Circuit would have approved of reasoning of this type, and perhaps, given his latest book, Justice Stephen Breyer of the Supreme Court would have approved of this kind of approach.
You mentioned oral argument, and we're going to include a clip of the oral argument in this recording and in the show notes. But the advocate for the development company had very little opportunity to say anything because Judge Wilkinson asked questions that kind of showed his reasoning and took up a lot of time during the oral argument.
First is, we pled.
Let me ask you something. Who has a better idea of traffic congestion in Chesapeake? And who has a better idea of the drainage capacities and the burden on those? And who has a better idea of whether there's sufficient capacity in the schools or not? Do we know that, or does the city of Chesapeake have a better idea? Why should we supplant our judgment on conditions in Chesapeake? What you want to do is you want to take this whole area, remove it from the people who were elected by the citizens of that county, and put it in unelected hands. You appeal to the, yes you do, you appeal to the Planning Commission, they're not elected. You appeal to a federal court, we're not elected. And meanwhile, the elected officials in Charlottesville and in Chesapeake who know what the conditions in that county are frozen out in favor of the Planning Commission, who may be able experts, but they're not elected. And we may be or may not be able judges, but we're not elected. We're not knowledgeable about what's going on in Chesapeake. And you want to put it in our hands and remove it from democratic accountability. That's where you're going.
So comment on that, Lawrence.
Well, it's not surprising to hear this kind of argument articulated by Judge Wilkinson. Judge Wilkinson is famous for his book, Cosmic Constitutional Theory. And that book is really best understood as an argument against the institution of judicial review. And in favor of a very high degree of judicial deference to democratically made decisions. So now, I just want to say there's an irony here, because the rhetoric of the book is sort of against constitutional theory. But then the argument of the book is not pragmatism. The argument of the book is for a constitutional theory that elected officials should not be constrained by judges and by statutory or constitutional texts. So there's a great irony there. it's a very unconventional position for judges to take in our system. There at least in 2024, where the institution of judicial review and judicial review in a variety of contexts, including this kind of context, is taken for granted as a basic part of our legal order.
Rachel, you published a paper on judicial institutionalism. Is there a bit of an interplay in what you were talking about there and kind of our discussion here today?
Yes, well, you could view this opinion as an institutionalist opinion, just thinking about the quote that you just read from Judge Wilkinson, this concern that having the court get involved here would mean, getting involved in an area that it lacks competence in, usurping the judgment of elected representatives, and potentially, and probably most importantly from an institutionalist perspective, courting some kind of blowback or criticism of the court's decision for inserting itself into matters in areas where it otherwise should not go. So one could view this decision as motivated in that sense by these types of institutionalist considerations.
And that's certainly true. I just would say, though, that this is a very unusual vehicle for establishing those concerns, because if we actually follow Rule 12b-6 and existing doctrine as it's conventionally understood, we're going to proceed to the next step. That will be summary judgment. And then we're applying rational basis review. So we're going to be highly deferential. All of the sort of democracy protecting features that Judge Wilkinson thinks are so important will then be brought to bear. It's just that they will be brought to bear at the right procedural stage instead of what was clearly the wrong procedural stage.
Greg, take us home.
Sure. At the risk of losing esteem in everyone here's eyes, I thought Judge Wilkinson's opinion made sense. I actually thought it was reasonable to say, the question of rational basis is on these facts, as you've told us. Can we imagine a rational reason the legislature would have done this? Or in this case, the zoning council? And congestion seems reasonable, and even if all of the other applicants were exactly the same, I think allowing one more might increase crowding even further beyond a breaking point. You could imagine that. So it's just to say I've been fascinated by this conversation. That was just my reaction reading it, and this was super, super helpful.
From the perspective of a lawyer, when I'm seeing them presenting 10 comparators and saying, you have, these are examples of similarly situated individuals that were treated differently, it seems like they did a lot of work at the 12b-6 stage, but it seems like for the Fourth Circuit it wasn't enough, even on the pleadings.
Yeah, well, I take that point. I mean, I could see this being a very fine slicing of the grain between the comparators. I guess I just wonder, we have room for 10 people in this classroom, and an 11th person shows up, even if the first 10 are all the same as the 11th. It seems reasonable that we, if the concern is congestion, not letting in the 11th would be rational, at least. I'm not saying it's a great idea. I think Judge Wilkinson says the voters can decide if this was a good idea, but seems rational, at least.
But outside the record.
That's a fair point.
And on that note of agreement, thank you so much for listening, and we'll see you guys next time.